the recording. Okay, so welcome everybody to the webinar. My name is Mike Fiffik. I'm an attorney at Fiffik Law Group here in Pittsburgh, Pennsylvania, and we are also the proud provider law firm for Legal Shield in Pennsylvania, and have been so since 1996, I believe. It's been a long and great relationship with Legal Shield. And for all of you that are out there, whether you're sales associates or maybe you're just business owners or thinking about to be business owners out there, I'm really glad that you've joined me. And I hope to share some helpful information with you today. And we're going to talk about business entities and legal issues for startups. That's going to be the topic of our webinar tonight. So here's what we're going to talk about today. I've got a lot of content in here, so it's going to be content rich for all of you. We're going to talk about why form a business entity. What are the reasons? Why would you think about doing it, right? When is a good time to form a business entity? That's a question that I often talk to folks who call me, who want to form one. You know, when is a good time to form it? Are you ready to do it? We're going to be talking about the business entity choices. There are a wide variety of them, and the pros and cons for each. We'll talk a little bit about business taxes. This isn't really a tax webinar. There are lots of things that we can talk about business taxes, but this is going to be some basics from more of a startup point of view. We'll talk about a little bit about the formation process. That can vary widely depending on what state or province that you're in or where you file, even though you're living somewhere other than the state that you file. And then what comes after the formation process. So those are the things that we'll be talking about this evening. Along the way, I would be very happy to answer questions. So what I'd appreciate is if you would drop them into the chat or Q&A, whatever it is in there. I will get to them at the end of the session, and maybe we can have a little bit of back and forth. If anybody wants to unmute, I'd be happy to answer some questions for you, as well. Let's see here. I'll make sure that everybody's muted out so we eliminate the distractions, and we'll go ahead and get started. All right. So why in the world would you want to form a business entity, right? Well, there are a variety of reasons for doing it, but one of the most important is to mitigate risk, right? A lot of people, whenever they're thinking about starting a business, or they already have a business and they're thinking about whether they should make it a little bit more formal, they are concerned about reducing risk, mitigating risk, and that means protecting their personal assets from claims that arise out of the operation of their business. So if some business-related matter comes up, they get sued by a customer or by a vendor, or somebody that was involved in an accident in some way relating to your business. Most business owners don't want to have their personal assets at risk if they can avoid that. So that's a big reason why a lot of people form a business entity. If you have businesses, a variety of businesses or business interests, you may want to form a business entity to protect the assets that you have otherwise in other businesses from the risks arising out of that business. If you think of a business entity as a box, it contains its assets, and it also is supposed to only contain its liabilities. And if you have your businesses, variety of businesses with their own assets in separate boxes, right? Each of those boxes, the things that are in that box shouldn't get out and impact what's in the other boxes, so to speak. So that's another reason why you might form a business entity or another business entity if you own other businesses. Some folks are looking for the credibility that comes with a formal filing to have Inc. or LLC or company or limited, after their name. There is a lot to be said for that. If you are going to be in business with one or more people, it's usually a very good idea to form a business entity, and especially to have some type of written agreement about your relationship to one another and your relationship to the business and your respective rights and obligations and liabilities. That's a really good idea. And we're going to talk a lot more about that a little bit later on. I think business entities are also excellent for estate planning. We talk a lot about estate planning here at my law firm. We do a lot of estate planning for folks. But for business owners, having a will, a power of attorney, a medical power of attorney or living will, those are very, very important documents for everybody. But also you can accomplish a lot of estate planning by forming and structuring business entities and creating agreements amongst the shareholders or the members of those businesses, which may end up being members of your own family. So there's a lot of estate planning and succession planning that can be accomplished by forming a business entity and structuring your business entities. When is the right time to form a business entity? A lot of folks will call to say, I'd like to form a business entity of some kind or another because I'm thinking about starting a business, right? Or, I have this idea that I want to run with, right? And they think that is the best time to start a business. It really isn't necessarily the best time to form a business entity before you actually get going with the business. Sometimes it's the best time, but other times it's not really all that important to do it at that time. So, here are some considerations that I would suggest that anybody that is thinking about starting a business, or maybe they've already started one, these are some considerations that might say it's time to start form a business entity. One would be when you need to take on some risk, right? Some businesses don't really have a lot of risk associated with them. Maybe you've got some kind of a side hustle where you're selling things on eBay or Amazon or some other online marketplace. Those businesses don't really have a lot of risk associated with them, unless, of course, you're selling some product that is inherently risky. But if you are selling stuff that you are taking out of the basement, or you're sourcing from other neighbors or whatever to resell them online, not a lot of risk arising. But that's not really a business that's going to risk your personal assets to any great extent. So, but if you're taking on some extra risk, right, where you're performing services, maybe you're doing construction work, or you're a home improvement contractor, maybe you've decided to drive a truck of some kind, there's some risks that come with that type of activity that may say, you want to protect your personal assets and get that business entity in the way or in between your personal assets and any types of claims that can arise out of your business. Another consideration is whether, if you are already operating a business, if you have sufficient revenue or income to cover the costs associated with the business activity. For many of these business entities, there are formation expenses, filing fees, advertising costs. In some states, you're required to have a registered agent. There's a fee associated with that. If you want to retain counsel, and I highly recommend that you work with an attorney and not do it yourself, there are going to be costs associated with that as well. So those are all costs upfront that business owners have to be able to afford out of their own personal kick or from their business revenues that you need to take into consideration. And there will also be ongoing costs to maintain or be associated with that business, like sales tax reporting, payroll tax reporting, insurances, tax returns, tax filings, things of that nature that are inherent with the formation and management of a business entity that you have to take into consideration when you're thinking about forming a business entity. So that's another consideration. The time of the year, I think, is also important. So if you call me on December 15th and you want to form your business entity, I probably will suggest that unless there's some urgent need to do it now, maybe that you wait until the calendar is turned to January. Even if you called me in October or November, I might say, why don't we wait until the new year? Why have to have any type of a business filing of some kind for a year where you basically did nothing? Might be a time to just wait on that. And then you might want to have some tax savings. There are some tax savings that you can enjoy by forming a business entity and filing the appropriate tax status election. We'll talk a little bit more about that later, but tax really isn't the number one determiner of when it's the right time to form a business entity, right? Sometimes it's a factor, but not usually, on the front end. So let's talk about the choices for the business entity. Sole proprietorship is one, general partnership, limited partnership, a corporation, and limited liability company. These are the basic types of business structures that are the most common. There are certainly others, right? Perhaps you might operate out of a business trust of some kind. That's very rare, but maybe you would. And there are different iterations within these categories as well. We're going to talk about some of those, but these are the ones that we're going to focus on because they are the most relevant. So some initial considerations in trying to decide which of these business entities is right for you. There's no one size fits all, right? You really have to tailor the business entity for whatever your business purpose is, whatever's going on with your business. So a limited liability company is not necessarily going to be appropriate for every type of business, or a partnership not appropriate for every type of business. So we're going to talk about those things in a little bit more detail as we dig into each one of these different types of entities. So, but here are some basic questions that I would be asking anybody before I would give them my advice about what's the right business entity for them, for their purpose. Do you plan to seek financing for your business in the future? And for most businesses, that's almost always yes. Are you going to borrow money? Are you going to get investors to invest in your business? Are you going to be applying for some type of grant of one kind or another? So that's going to be important question to answer for purposes of figuring out what business entity is right for you. Will your business own and hold real estate? Very important consideration for business entity selection. There are just some types of business entities that aren't good for owning real estate, either from a management point of view or from a tax status point of view. Will your business operate in multiple states? Again, that's an important consideration, especially for your shareholders or investors. If you have multiple ones, that you want to try to simplify the tax filing as much as possible for them. And so, certain types of business entities make it a little bit easier than others. Will your business have more than 100 owners? For most small businesses, this isn't really an issue. But if you're going to be seeking financing or maybe small dollar financing from lots of different people to operate your business, I don't run into too many of those, but sometimes we get folks that want to do that, some type of sort of crowdsourcing. That can be an issue, especially as it relates to certain tax status elections that would be available for you. Do your investors have a preferred entity type? So if you have investors, they're going to be giving you substantial amounts of money. They may prefer that you form your business in one way versus another. Could be some tax advantages for them, can be some structural management rights types of questions that they would, the aspects of one business entity versus another that they would prefer to have. If you've already formed your business entity and you're out there operating and it's the wrong one that investors don't want, then that's going to be a material factor in your ability to attract certain types of investors in your business. And if your business is planning an initial offering, that's going to be an important consideration as well, meaning publicly traded, right? Being offered out there for sale for shares in your business. Almost always that's going to have to be a corporation. So I don't run into too many of those as well. So let's dig into each one of these and talk a little bit more about them. So I'm going to cover each one of these and I'm going to have the same outline for each one. I'm going to tell you a little bit about the basic structure of the type of entity, the core documents that are usually associated with it, maybe a couple of comments along the way. And then we're going to talk about the pros and cons, each one of these. So sole proprietorship is the first one that I wanted to cover with you. And this is a business that is owned and operated by a single person, right? And there's really no distinction between the owner and the business, other than maybe the business is operated under some type of a trade name, like, Joe's Painting Service or something like that. It doesn't, a sole proprietorship can have what's called a DBA, doing business as, or might even file for a fictitious name. But the fictitious name is just the legal right to enter into contracts, under that name. But it doesn't mean that it's a separate business entity. It's still you, the business owner, right? There's one and the same. The core documents, there really aren't any. There's no filing with the state required to form a sole proprietorship. It just exists, under the law. Sometimes you'll need to have a tax identification number, especially if you're going to have employees. You'll probably need a tax ID number of some kind. So that's a basic filing that some sole proprietors might have. And I mentioned before, you may want to file for a fictitious name, a doing business as name. When you do that, you don't get a lot of benefit out of it, at least here in Pennsylvania. And that's where I practice. It might be different in other states. But, a fictitious name filing, again, it doesn't mean that you're a business entity. It just gives you certain rights to operate under that name. But questions that you might want to ask before you plunk down some money to file for a fictitious name is, first and foremost, understand what's involved in filing for a fictitious name and the costs involved. In some states, they might be surprising to you. Could be run into several $100s. Secondly, if you file, are you going to be given exclusive rights to operate under that name? Exclusive meaning whether your state regulator will give that identical name to somebody else that asks for it. It's not a trademark. It doesn't give you the right around the world or in the United States to use that name. It's just that your state regulator, you want to know whether or not they're going to give somebody else who files next week with the same name, they're going to let them use that name too. So is there exclusivity, right? Those are a couple of questions that you'll definitely want to ask before you file for a fictitious name. Comments, this is a default business form. So if you start, your kids, they go out on the street, have a lemonade stand, that's a sole proprietorship. It's sort of a default business form whenever you're just operating a business. You're selling pies at the county fair, you have a sole proprietorship. It's just arises under the operation of law. And so it's ideal for, little startups, local business ventures that, aren't inherently risky, or might be a side hustle of some kind that don't have a lot of risk, to them. That's what a sole proprietorship is kind of ideal for. Something that maybe you're just trying out as an idea and you don't really know whether you're going to run with it or not. Maybe you made some crafts for gifts and everybody loved them, and now they want you to make some more and start selling them, online, and you've decided to have a little cottage industry of making little crafts, along the way, but it's just a little side hustle, something that you do in your extra time kind of a thing. So the pros and cons for sole proprietorships, the pro is it's easy to start, right? Very few, if any, legal filings required. So it's very inexpensive, very simple. You just start doing, right? That's basically what a sole proprietorship. The downsides, the cons are that you've got unlimited personal liability for the business claims and debts. So let's say that your business is making cookies and selling cookies, in your local neighborhood. You're the cookie lady or the cookie guy, and you make a cookie and somebody gets sick and sues you, you're personally liable for whatever that claim is. There's no liability shield there for you. A sole proprietorship means you can have more owners. It's a sole proprietorship. If you have another owner, it automatically becomes a general partnership, and that's the next thing that we're going to talk about. If you pass away, it goes away. Your sole proprietorship doesn't exist beyond your death. You are the sole proprietorship. If you aren't around anymore, the sole proprietorship is pretty much gone. And it's really difficult to sell the sole proprietorship business. There's really nothing to sell there, right? Other than maybe the tools of the trade or the assets that you have. There's really nothing to sell with a sole proprietorship. So let's move on to general partnerships, the second of our business structures that we're going to discuss today. So this is an association of two or more people to carry on a for-profit business. And again, the only real difference between a sole proprietorship and a general partnership is that a partnership has two or more, right? Two or more people who own or operate the business. Again, there's no distinction between the business and the partners. So the business is your own personal asset. You are personally liable for all of the claims arising out of the general partnership. Be careful for what I will refer to as hidden partnerships. That's my term. That's not a legal term. That's just Mike's term, right? But you could be surprisingly in a partnership and you don't even know it. Examples, if you're on a deed with somebody else, whether you're related to them or not, you are in a partnership. You own an asset that you have responsibilities for in the way of carrying costs. Perhaps it's income producing. Maybe it's a rental property of some kind, or maybe it isn't income producing at all, but it's an asset. And each of you has an ownership right to it. You have liability for the claims that arise, out of the property. Maybe each of you has to contribute to carry the carrying costs, whether that's taxes or maybe you have utilities or upkeep or whatever it is. That's really a partnership. Owning a piece of property together is a partnership. We don't think of it like that whenever we own it with our spouses or maybe with other family members. But we might be more likely to think about it that way if we own it with somebody that we're not really related to. But that's kind of a partnership. That's the way you should think about it. If you're a co-owner with somebody on a tangible asset, meaning something that you can pick up and move or drive, like a car or a truck or a piece of equipment that you're using in a business that you co-own with somebody. Again, now you're in a partnership, at least in that asset. You might even be a partner in the business that you use for the business. I've been involved in many disputes over the years of folks that are in a general partnership, because that's what it is under the law, whether they think that they have a partnership or not, whether they call themselves a partnership or not, they are in a partnership. That's what the law calls that association with one another. And there can be a lot of confusion about what their responsibilities are to one another, what their rights are as it relates to the partnership. Maybe you've got two guys that are operating a home construction business. This is a dispute that I've litigated over in the past. And one guy is the one who bought equipment for the business, right? Maybe the other guy thinks that they're using it in the business, that it's owned by the partnership. Well, when the dispute arises, the guy that bought it all of a sudden claims that he individually owns the equipment for the business. And now we've got a misunderstanding or a dispute about that. Or maybe one of the partners is taking a lot of money out of the business unbeknownst to the other guy or other gal. And that ends up being a dispute. Those are the types of problems that can arise in a general partnership. So no documents are really required for a general partnership. Again, if two people are cooperating with one another to operate a for-profit business, it's a general partnership, whether you have a partnership agreement or not. It's not necessary to have a written agreement, but I highly, highly, highly recommend that you do, right? A lot of misunderstandings can arise out of that. And usually a general partnership will have a tax identification number of some kind, although it's not necessary, right? You might just have a bank account that has both of your names on it, and that's what you use to write checks and deposit checks for your general partnership. If the partnership has a name that's associated with it, probably will have a tax ID number of some kind so that you can open a bank account in the name of that business. Couple comments to share with you. If you don't have an agreement with your other partners, the default governance rules is the state law. There's a Partnership Act in Pennsylvania that sets forth sort of the rules of the road for general partnerships. And, I've said this before when it comes to doing estate planning and how important it is for you to have a will. If you don't have a will, I always say, don't worry. The government's got a will for you. It's called the Laws of Intestate Succession. And everybody trusts the government to take care of their family, right? The government knows exactly what to do to take care of your family, just like you would. Of course, that's ridiculous. It's a preposterous thing to say. And I would say the same thing for people that are in a general partnership. Don't worry if you don't have a written agreement. The state has a partnership agreement just for you. And it, of course, will be exactly what you want. It isn't, believe me. Don't rely upon the government's partnership agreement for you. You don't have to abide by it. You can agree to your own rules for how you're going to govern your partnership. So it's very important to have a written partnership agreement. I would also say that a general partnership, again, is not appropriate for any business that has risks coming out of it, because again, the general partnership, there's no difference between the general partnership and you. Each partner is personally responsible for their respective claims that arise out of the partnership business. So the pros, easy to start, few if any filings required, relatively simple and expensive to operate in most instances. Now, if you have employees and things of that nature, it can get more complicated, but generally, it's relatively simple to operate. The cons, we've touched on this before, unlimited personal liability. So the partners are jointly liable for business claims and debts. And, if the general partnership has claims and somebody comes a suing and gets a judgment against both of you guys, and one of you doesn't have any money and the other one does, the one that has all the money is going to end up paying the judgment. So, you can't say, well, I only owe half, right? As the claimant's going to be able to collect it all from you, most likely. Most partnerships have no written agreement. So there's a lack of clear rules on governance, financing, succession. If somebody dies or is disabled, what happens to the general partnership and their interest in the business? And it's really difficult to sell your share of a partnership without some type of agreement. I mean, who wants to buy your share of a piece of property that you own with a partner when there are no rules about, whether you can sell the property, whether you can borrow money on the property, how much money you have to invest into the property in the event the revenues are insufficient to pay the bills. This is just a sampling of issues that are relevant to general partnerships. So it's hard to sell those. You're not going to be able to sell it most likely. And you don't want to leave it to your kids, because basically you're just passing the same problems down to them, that you have. And they only get more complicated when you pass them down to the kids. Instead of it being your problem, now it's your kids' problems plus your old partner, and so on and so forth. They can get very complicated. So let's talk about limited partnerships. So the basic structure, again, is two or more people working together in a for-profit business. We have some new concepts here. We have the different types of partners, right? A general partnership, everybody's the same. But with a limited partnership, we have the concept of general partner and of the limited partner, right? Two different types. They have different characteristics. The management rights and control of the business and the decisions relating to the business are typically invested in the general partner, right? And then in the limited partners, they usually have the equity interests only, but they don't have voting rights usually. They lack control. They lack the power to make decisions for the business. That's how limited partnerships are set up. And so the core documents, now you get into a business entity that's going to start requiring some filing with your state. You'll typically have a certificate of limited partnership that's filed with your state regulator. You should have a partnership agreement, although it's not required by law. It's certainly highly advisable for all of the reasons that I mentioned before relating to general partnerships. and it will almost always have some type of a tax ID. Limited partnerships are really interesting business entities because they come with a lot of flexibility. They are flexible from a planning perspective, especially for estate planning. They can be very flexible for revenue distribution amongst the partners. They are flexible from a control standpoint. So limited partnerships are good ways to maintain control of the business entity and the decision making that has to happen for it, without really retaining a lot of the equity rights to the business. So a general partner can be have a 1% equity interest in a limited partnership, but maintain 100% of the control over the business, whereas 99% of the other equity interests might be owned by the limited partners, and they're getting the equity, the money that's produced by the partnership, would enjoy the capital returns in the event of a sale of a partnership assets of some kind, without really having any of the control aspects in the business. And so this can be really good for a family business of some kind, and especially for estate planning and succession planning for a family business, where maybe the parents or the grandparents want to pass some of their equitable stake in the business to their family before they pass away. There are some tax advantages for doing that, but they don't want to hand over the control reins to the family because the family may not be involved in the business. And so grandma or grandpa still need to run it, or maybe only some of them are involved, but not others. So or you want to protect the interest in the business from creditors and other claimants that may sue your grandkids or the other partners in the business. And you can do some protection of that. So there's a lot of flexibility here. It's really good for family businesses, maybe some real estate holdings, those types of things. The pros, limited partners are not liable for the business debts. So there's a liability protection aspect to limited partnerships, and that's it, right? Limited partners not liable for the business debts. Now, the general partner is liable for business debts, but you can mitigate that liability by having the general partner be another type of a limited liability business entity. Oftentimes, the general partner is an LLC of some kind that if you're the one that's behind putting this all together, you're the owner of that LLC. And so you protect your own personal assets by layering those business entities. If you recall at the beginning of my presentation, I said one reason to form business entities is to protect your own personal assets, but assets of other businesses from one another. That is kind of an example of that. The limited partners can be a trust or a business entity. There are some wrinkles that you get into about that, depending on the tax status of the partnership. But that's very common for, let's say, a family that has a family business that is using a limited partnership for estate planning or succession planning, and you want to transfer your ownership interest in the business to your kids or your grandkids during your lifetime, because you get some tax benefit out of that, potential tax benefit. But you don't want them to really control it, and you want to protect what they own from divorce or from their own creditors. You might make the limited partner, the limited partner interest owned by a trust, right? And the kids don't have any control over it. And the decision making for the limited partners is vested in a trustee. And so you can protect those interests in the business by using a trust to be the owner. Partnerships also enjoy pass-through tax treatment. And we're going to talk a little bit about that further, but there's no tax on the partnership. All of the income, all of the capital gains that are earned by the limited partnership are not taxed at the partnership level. Rather, they are passed through to the partners, allocated in whatever way the partners have agreed. And that's part of the flexible structure that is a benefit for limited partnerships, is that you really have a lot of freedom to allocate the economic interests of the business among the partners, to allocate management rights, and equity interests. So there's a lot of benefits to that. Another benefit, which we don't really see with the sole proprietor and the general partnership, is that the limited partnership will continue even after the death of a partner, because it's a business entity. It's its own person. It continues to exist even though one of the owners passes away. Once that owner passes away, their ownership interest in the business passes to their estate, or maybe to a trust or whatever they've provided. But the business itself continues on after the owner passes away. So some of the cons of a limited partnership, again, if you want to consider it a con, this requires some state filing. So there's some costs associated with it and some additional tax returns that will have to be filed. So, they're a little bit more complicated. And so you're going to have to pay some money for a CPA or for somebody to do your taxes and maybe even do your bookkeeping work, along the way. It's not an ideal, sorry for the typo there, it's not an ideal structure for seeking financing. So if you're looking for a bank loan, or especially if you're looking for investors, it's not really an ideal business structure from an investor's point of view. They may not be interested in lending into it. Limited partnership shares may be difficult, if not impossible, to sell because they don't come with any type of control over the business. So somebody is not going to necessarily be interested in buying a limited partnership interest if they have no decision-making power over the future of the business. So I don't think I've ever seen limited partnership interests sold unless the whole business was sold. That's just highly unusual. And in fact, the partnership itself may have restrictions on a limited partner's ability to transfer their membership interests or their partnership interest to somebody else. Now, one of the downsides of limited partnership is that partners have the right to withdraw without prior consent of the partners. So, that can be a downside. Somebody wants to get out of the business. That's not always a right that you have in some of these other business entities, but with a limited partnership, it is something that they can do. And, there's not a lot of litigation involved in limited partnerships out there. So the case law is relatively sparse. So there's not a lot of guidance under the law for the governance of limited partnerships and any of the disputes that arise there. Just not as much as you have with corporations or limited liability companies or other business type of entities. So let's talk about corporations. So I think we all are relatively familiar with the basic structure of a corporation. It has shareholders, those are the owners, the equitable owners of the business, right? The ones that derive the most economic benefit from the business. You have a board of directors. Board of directors don't have to be shareholders. They can be, but they don't have to be, right? They are charged with the overall governance of the business and the ultimate decision-making authority. Although the real ultimate decision-making authority is vested with the shareholders because they're the ones who appoint the board of directors and can typically remove the board of directors. That's how a shareholder exerts their control over the business entity, by appointing and removing members of the board of directors. But the board, by and large, has oversight for governance and the larger decision-making and policy-making for the corporation. The officers are charged with sort of the day-to-day management of the corporation. The core documents, and these terms might be a little bit different depending on what state you're in, but these are general concepts. Articles of incorporation, typically filed with your state or provincial regulator. Bylaws, which are sort of the rules by which the shareholders are related to one another, the board of directors, how it's managed. That'll include voting rights, types of classes of shares. You might have, and the rights that come with those classes of shares, you might have A shares, B shares. Some are worth more than others. Some may have voting rights, some may not have voting rights. Some may have preferential treatment for distributions of cash in the business, and some may not. So it'll involve all of that stuff. Restrictions on the shareholders' ability to sell their shares or transfer their shares. What type of vote it takes to terminate the corporation or to sell its assets. Those are all examples of provisions that would be in the bylaws. You'll have a minute book, which is where the governance and business relating to management of the corporation or exist, not the day-to-day stuff like ledger, checks and things of that nature are written, but overall decision-making authority is contained in the minute book. Corporations typically have to be advertised when they're formed, so there's some costs involved with that. They usually issue share certificates, but not always, especially with small corporations. It's not unusual that the share certificates aren't actually issued, but they should be. And they will always have a tax ID number of some kind. So, corporations really are the most rigid business entity form that you can pick, right? It's rigid in its structure, it's rigid in its rules. It's just the most set. But because of that, it's better for seeking financing, for public offerings, and for operations in multiple states. So people understand corporations very well. And so they're a little bit more favored from an investor standpoint. So there are a wide variety of corporations. These are just some examples of what you might find. It's going to vary from state to state. There'll be all different types of corporations that are authorized under your state's law. But here's some examples. A professional corporation, and these are reserved for businesses where all the shareholders are a licensed profession of some kind. So lawyers oftentimes have PC after them, which means professional corporation. That's what my law firm is. You might have a registered corporation, which is publicly traded. A non-stock corporation, which is a corporation that just doesn't have shareholders. You might have a non-profit corporation, or not-for-profit. Those terms are synonymous with one another. A not-for-profit corporation, it doesn't really benefit its members or its shareholders. It usually is dedicated to some type of a public benefit. Not-for-profit corporations may or may not be tax exempt under the IRS rules. They typically are, but the tax exemption is not something that is inherent in the not-for-profit corporate entity formation. That's the corporation is under state law. Whether it's tax exempt is a matter of federal law. And you have to apply for tax exempt status and qualify for tax exempt status if you are a not-for-profit corporation. And then something a little bit newer out there in the world are called benefit corporations. And these are for-profit, but they also have some public benefit aspect to them. So those are just examples, not terribly common, but just an example of what's out there. So the pros for corporation is that the shareholders aren't liable for the business debts. The corporation will continue after the death of the shareholders, and it's a better entity for seeking financing. The cons are it's usually the most expensive to form. Advertising, the requirement for advertising adds to the expense. It has the highest ongoing expenses for maintaining corporate formalities, producing resolutions, having minutes of meetings of the board of directors and of the shareholders. And you want to do those types of things because they will help protect the shareholders from potential personal liability for business debts, right? They're inflexible, right, from a structure standpoint. So the allocation of economic interest is based solely on share ownership, right? So if you're a 20% shareholder, typically you're going to get 20% of the economic interests associated with the business. That's not always true, but as a general rule, That's the way it works. And I will say that there's a big difference between having being a shareholder and having a percentage interest in the business and what you get from a cash perspective out of the business. They're two entirely different things. It's not unusual for, let's say, a 30% shareholder of a corporation to never see a dime out of the business because the money that's generated by the business is paid out in other ways before it ever sort of hits the waterfall and flows to the bottom line being the shareholders. They get paid last. There are certain dissenter rights for minority shareholders that are provided under the law that some businesses would like to avoid, so they can control exactly what's going on with the business without having to deal with minority shareholders disrupting the intention and the plans and the goals of the business. And corporations also come with the potential for double taxation. And I'm going to talk a little bit about that later, so we'll stick a pin in that for now. Finally, we have limited liability companies, and this is really the most common type of business entity that people choose right now. It has its basic structure can be for one or more members, right? So you can have a single member limited liability company or multi-member. It also has the concepts of general partners and limited partners, except for LLCs. The general partner is usually called a manager, and the limited partner is usually called the member, right? But you can have member managed businesses where the owners are the managers, meaning sort of control is vested in the shareholders, so to speak, to mix and match all of the terminology. Or you can have a manager managed LLC, meaning you've separated the equity, the equitable interest in the business from the management aspects of the business. So the manager can be a 1% member, but can have 100% of the control. So you can separate this, just like in a limited partnership. The core documents here do have to be filed with the state. And again, these terms change depending on where you are, what state you live in or province you live in. Here in Pennsylvania, it's called a certificate of organization that's filed with the state. There's an operating agreement that's not filed with the state, but that's an agreement, just like bylaws are to a corporation, an operating agreement is to a limited liability company. It's those rules of the road that govern the rights and relationships of the members and the managers to the business. And it'll typically have a tax ID number of some kind. So this is, I call it a default business form, but it's what most people will pick, right? And it's the best overall for most ventures, good for real estate holdings. It's good for a lot of different basic businesses. It's less expensive to form than a corporation, but it comes with that liability protection. So the members are not typically liable for the business debts. Now, there are exceptions to that rule. No matter what business entity that you have, there are some liabilities that owners of a business are going to have, depending on what the situation arises. But typically, the general rule is that a member of an LLC is not liable for the business debts. This has a flexible structure, just like partnerships. You have the freedom to allocate economic interest among the partners, to allocate management rights, good for passing equity interests without losing control. So you can really divvy up the pot of money lots of different ways in the LLC structure. So it's really good. It gives you the broadest choice of tax status elections as well. And again, when a member of an LLC dies, it continues. Very few cons with an LLC. It has to be filed with the state. So there's some costs involved with that, but that's it. So I'm going to have to hurry up here because we're getting long. Let me talk a little bit about taxes. Sole proprietorship tax. The business is not a legal entity for tax purposes. And so for a sole proprietorship, all of the income of the business and the expenses and the losses are reported on the business owner's personal tax return, right? So they will file what's called a Schedule C with their tax return. They're also responsible for paying self-employment tax on all of the earnings from the business, and that's at 15.3%. So it's a pretty hefty bite. But those are the tax ramifications of a sole proprietorship. General partnerships also do not pay business income taxes because these are pass-through tax entities. This is kind of a sole proprietorship except for 2 or more people. So each owner reports their share of the partnership's income and losses on their personal tax returns. The partnership will have to complete and provide a Schedule K-1 to each owner, which is like a W-2 or a 1099. It just says this is your share of the earnings of the business that you have to report on your own individual tax return. And income for general partners is usually treated as self-employment income. So you're going to have to pay self-employment taxes on the money that you earn from a general partnership. And the partnership itself has to file. It's an information tax return. It's a Form 1065, with the IRS. Limited partnerships are very similar to general partnerships, but they have some benefits. If the losses in a limited partnership are greater than the profits, partners in a limited partnership can deduct some losses up to their investment in the business. So you can take some write-offs if there are losses. They'd be allocated to the members of the partnership. Since limited partners don't participate in the management of the business like a shareholder would or like a general partner would, their income is usually passive income. And typically only the general partners are the ones paying self-employment tax on their earnings from a business that is operated as a limited partnership. So there may be some benefits there from a tax perspective. Always best to talk to your CPA about the tax-related matters. Corporate tax considerations. Corporations are taxed separately from their shareholders, and they have to pay income tax at the corporate level in most states. So the corporation pays its own tax, and then profits that are paid to the shareholders, often called dividends, can be taxed as ordinary income. Now, some certain types of dividends, which are called qualified dividends, are subject to lower tax rates between 0 and 20%, depending on your income tax bracket. And there are criteria that you have to meet in order for the dividends paid to you by the corporation to be considered qualified dividends for that preferential tax treatment. And they're not terribly difficult to meet in most instances. So what is an S corporation? I get this question all the time. People ask about S corporations. I want to form an S corporation. So an S corporation is not a type of corporation. The S refers to a provision in the IRS code. It's a tax status that a corporation elects to have. So a regular corporation is what's oftentimes referred to as a C corporation. It also refers to a provision in the IRS code. The S is a different provision. So S corporations are C corporations who have elected no longer to be a C, but rather an S corporation. And basically what they're doing is they are electing to be a pass-through tax entity, meaning the profits and losses of the corporation are passed directly through to the shareholders. There's no more tax at the corporate level and at the shareholder level. That's that double taxation that we referred to. It is only at the shareholder level. There are some limitations associated with the S election for corporations. There are some limitations on the number of classes of shares that a corporation can have and the rights associated with those shares. Usually the only real difference between a class of shares is whether one can have voting rights or not. Anything beyond that, you won't be able to elect S status. And if your corporation has more than 100 shareholders, again, you won't be able to have an S status. There are other restrictions, but those are the ones that come up most frequently. So briefly, if you are forming a business entity, the formation process usually involves these steps. First, you'll normally obtain an EIN, an employer identification number, often called a tax identification number. Those are synonymous terms, one and the same. and you file the IRS form SS4 to get that. Oftentimes the EIN number is something that you have to include on the filing that you're filing with the state. That's the only reason that you would get it first. Then you'll file your certificate of organization or articles of incorporation or certificate of limited partnership, whatever it is, with your state regulator. And then you wait, right? You can usually file it electronically if you're using the state forms. You don't have to use the state forms. You can come up with your own form and use that. And the time for processing your application varies from state to state by time of year. We were really backlogged in Pennsylvania a couple of months ago where it was taking up to 6 weeks. Now I think it's, back to something relatively normal, which is a couple of weeks is what we're seeing in the lag time. So you don't want to, wait till the very last minute to form a business entity. Let's say that you're forming one for purposes of acquiring real estate. Don't wait until 2 days before the closing to try to form your business entity. It'll be too late. You need to allow for enough time to do that. You'll typically receive some type of acknowledgement from the state once your paperwork has been successfully processed. That'll either come to you by hard copy mail or email or maybe both. If there's a problem with your filing, you'll normally receive that back with a request that you correct whatever the deficiency is. But most state regulators, once they clock your paperwork in, even if it's defective and they send it back to you, if you do correct it and send it in a timely fashion, your business entity will be backdated to that original clock-in date if the timing is important to you. Maybe it is, maybe it isn't. It really depends on the situation. Some states are required to have a registered agent. And a registered agent really is just a name and address where legal papers can be officially sent, that service can be quote unquote accomplished. So some states require that. Not every state does. Even if you're in a state that doesn't require it, you can have a registered agent for your business. So if your address is relatively unstable or transient, you're not sure you're going to be in the same place for a long period of time, then it might be a good idea to have a registered agent because, that address typically isn't going to change. And all you have to do is tell your registered agent where to find you, or they'll get it back to your last known address and get it to you. So there's some stability out there so you don't miss the filing of important paperwork from your state or claims or other types of notices that are important to you. You should prepare an operating agreement or bylaws or partnership agreement. Again, it's not necessary, but if you don't do it, then the state's rules governing your partnership, your corporation, your limited liability company are the default rules for your business. And they may not be appropriate for you. They may not be what you want. 9 times out of 10, they aren't going to be what you want. And so you will want to exercise your right to have an agreement that is different than what the default rules are that the state has for you. Don't let the state make decisions for your business. It's too important. The state can't make good decisions for your business. So don't rely upon the state's default bylaws for your business to run your business. That is usually a foolhardy thing to do. Another reason why you're going to want to have this agreement is that you're probably going to have to produce it at some point along the way for certain types of transactions. If you borrow money from a bank, they're going to ask to see your operating agreement. If you're trying to sell your business, the buyer is probably going to want to see your operating agreement or bylaws. If you're selling real estate, you're going to have to produce a copy of your operating agreement to prove who has authority to sell this real estate, to sell these assets. There are a lot of transactions that you're going to be involved in where you're going to have to produce signed copies of all of your business entity documents. So it's a good idea to get them all in place. There can be consequences for not having them. You might not get that loan. You might not be able to sell that property. Maybe there's a delay in your ability to close on those transactions that cost you money in the way of getting requalified for your loan or the interest rate goes up, especially now. That's a real factor. So get all your paperwork together. It's really important. For corporations and maybe LLCs, you want to have some initial resolutions approving the formation of your business, appointing officers so that you can prove up that they've got authority to do things and transact business on behalf of the company. Maybe you want to issue share certificates. So that's all part of the initial formation process. And after that's done, after your business is born, right, things aren't necessarily done yet. You want to save all of your formation documents in a secure location so that you have them handy and readily available in the event that you need them. You'll want to open a bank account. You should register your business with your state taxing authority of some kind. That's usually required that you register with your taxing authority in your state or your province. If you don't, the Corporations Bureau is going to let them know, and they'll find you one way or the other. So they'll catch up to you, but usually you're better off filing there because you want to provide them some information about your business. You may also need to register your business with local regulators as well. So you have to check your local municipality to see if there's some type of general business license that you have to pay for and get in order to do business. If you want to elect a particular tax status for your business, there's usually a time period within which you have to file those tax elections. And then you might consider applying for a special status. Maybe you're a women business enterprise or a minority business enterprise or a veteran business enterprise. And those can give you some advantages or open some doors for grants and other types of programs that are favorable for your business in your state. Don't overlook some other important documents that you might want to have prepared, such as employment agreements, shareholder or owner agreements, business power of attorney, loan agreements. If a shareholder loans money to the business, there should be some type of agreement that says how they're going to get paid, when they're going to get paid, and whether they get paid before the other shareholders get paid dividends and things of that nature. Very important thing to have in place. Employment agreement, very important for a small business owner to have. Just because you're an owner of the business doesn't mean that you have a right to also be employed by the business. And if you have multiple owners of a business, it's not that unusual for disputes to arise where, a minority business owner who thought that they were guaranteed a job get fired, so to speak, by their other business owners. And there's really nothing that they can do about that unless they have an employment agreement that entitles them to some type of process or procedure before that relationship can be severed with the company. So it can be very important protection, especially for minority business owners, to have to protect their ability to draw money out of the business and sustain their livelihood. And then maybe there are other types of agreements that the business will sign, such as management agreements for real estate deals. There might be license management agreements or property management agreements or developer agreements, lots of different types that are intended to organize the relationships amongst the parties connected to the business, to direct the flow of revenues from the business, to allocate rights and liabilities amongst the business owners and obligations. So, in summary, I'm sorry we went a little bit long here. I'll get to your questions in just a moment. But again, every business is different. There's no one size that fits all. So it's really important to take some of these considerations that I talked about earlier to heart before you decide which business entity you're going to do. Don't skip any steps, complete everything. It's really important to not skip a step. It is so common, especially when I run into people that have worked with some type of a DIY business formation service, right? And all the ones that are out that are advertising the business formation. They oftentimes don't complete all of the steps in the business formation. Their business files the basic filing documents with the state regulator, and then that's it. That's all they ever do. And they don't have bylaws, don't have operating agreements. And sometimes this can be a real problem for them, especially if there are multiple business owners and a dispute arises. It's even more problematic because these folks that do these DIY services don't understand what they have. They don't understand their documents. They don't understand what they mean and why they're important. So that's another problem that I see that arises there. And I highly recommend that if you're going to start a business, I know budget is often very, very important, but the mistakes that you make at the time of startup can really come visit you in a way that would not be very happy later on down the road. And so it's really not something to skimp on at the very beginning. You want to work with an attorney that is experienced in business law. You want to work with a CPA that has experience with doing tax work and advising small businesses. It's really important to get all of those decisions made upfront and get started on the right foot. It's like building a bad foundation for your house, right? Because you wanted to save a couple of bucks. I like saving a buck just as like anybody else does. But if you build a bad foundation and then put a nice house on top of it, the house is only worth what the foundation is worth. And, eventually that foundation could crumble, fall, leak, crack, all kinds of problems. And then you got real problems, and sometimes they come at really inopportune times in the life cycle of your business. So, don't skimp. It's a little bit of an extra expense to get some advice at the startup phase of your business, but it really is money well spent, and it will save you money down the line. And so that's it for the presentation. If you have any other questions or want to contact me, this is the link to my website, and we have lots of materials on my website for business-related matters, including all kinds of questions about LLCs. There's a ton of information there for you. So let me stop my share, and I am going to answer some. Should I see if I can answer some questions in the chat here? Let's see what we got. So June asks, would it be better earlier in the creation of a business who deals with making foods to have an entity sooner rather than later? Again, it really depends on how much revenue you have and what type of risk that you're taking, right? If you're making some cookies casually that you sell periodically, I don't know that it's terribly important to have a business entity, especially if you're operating in a way that's safe, not out of a dirty kitchen and all that kind of stuff. There's a lady, I call her the cake lady, up in my neighborhood. She has the most fabulous cakes. Every time I have an event, I buy cake from her. I wouldn't form a business for her. She's just selling cakes out of her kitchen. They're really great, but I don't think anybody's going to die from eating a cake. So I don't think there's a lot of risk. I would really take the risk into consideration with a food type business to decide whether, you needed to form some type of a business entity. Yeah, Jimmy says, ouch, I learned the lesson very hard when I had a general partnership and somebody took chunky cash out. Once the cash is gone, it's tough to get back because usually they spend it on something and they don't have it. They can't be able to pay it back. We've had a lot of litigation claims involving that type of a thing, some iteration or another, and they're always problematic. Randall, you're saying, so to be clear, we should avoid business formation services that don't offer operating agreements and other important documents. Yeah, absolutely. I would stay away from it. I would stay away from DIY formation entities only. They sort of suck you in for the low price, but you kind of get what you pay for, which is not a whole lot. So you would definitely want to do that. How do you find out if you can be deemed as an MBE, a minority business enterprise? Those are going to be governed by either your state, like your Department of Community. If there should be either your Corporations Bureau, there should be some type of a Department of Community and Economic Development. That's the one in Pennsylvania. Department of Labor those typically are going to have certifications of one kind or another for minority business enterprises, women-owned business enterprises, and you should check what the rules are. They're going to be different in every state or every province where the business is located. So they should check on that. And there may also be those types of regulations at the local or the county level or the regional level as well. Sometimes if you qualify at the state level, you've sort of already met the qualifications at the local level. The veteran ones are typically governed by the Veterans Administration, but there may also be other regulations with governmental entities that engage in contracting with small businesses. So that's normally where I would look. I'm sorry, I can't give you a particular website. There's no one size fits all for that either, but it is by state. The recording will be available on our YouTube channel. So if you search for Fiffik Law on the Fiffik Law Group on YouTube, this will be posted, not later today, but probably later this week, it'll be there.
Mike, I'll post the URL to our YouTube page in the chat.
Thanks, Naomi. Harvey asks, is there a benefit of establishing an LLC in states like Wyoming? There might be. I get this question sometimes, should I form it in Nevada? Should I form it in Delaware? And what I typically say is it depends on what you want, right? Each state has its own attributes, and I can't really place a value on what's important for you, right? If privacy is important for you, then that might dictate filing your LLC in a state other than Pennsylvania, because there is some information, public information available, not a lot, but some that's available about you that you might not even want to be available. And so you would want to file in a state where you can hardly get any information at all. Maybe there are no state taxes on LLCs in certain states, and you want to take advantage of that. But you got to have enough revenue, right? One of the considerations for forming an LLC or any other type of business entity is, do you have enough money to pay the carrying costs associated with the business? And whenever you file in a different state, you're sort of multiplying those carrying costs, because now, you're going to have to file tax returns in the state where you're doing business, and you probably have to file some returns in the state where you filed your LLC and maybe not operating there. So there are complications involved in filing a business entity in a state where you don't intend to operate the business. You might have to register your business as a foreign corporation if you filed in Wyoming, but all of your business activities are in Pennsylvania. So those are all cost factors that come into play. You got to sort of weigh your return on investment, right? What are you getting in return for the investment of all that money on the ongoing basis by filing in a different state? Let's see. Carol asks, relative to Legal Shield's launch package allows formation of an LLC for one person. Would the other formations be covered under the 25% discount? That's a tricky question. I can't speak for every provider. I would say there's no specific answer under the membership agreement for this. But the 25% discount, let's sort of address this. It applies to hourly engagements only. So if you're hiring a lawyer on an hourly related matter, the discounted services apply to the hourly matter, right? The 25% discount does not extend to matters that are flat fee engagements or that are contingency related matters. So the 25% doesn't apply to everything. That you have to understand that first and foremost about pretty much any of the Legal Shield plans and the discounted services that are available under those plans. Now, that being said, if you're working with a provider law firm, they will probably extend some level of discount for the formation that are not just plain garden variety launch formations, which are single member, business entities. So I can't speak for everybody, but I believe that would probably be what you would find. And you should really talk to your provider firm if you're a Legal Shield member or an associate to find out what they do, and they can tell you specifically for your state. Ian asks, what would be a good business structure for e-commerce stores selling on Amazon and eBay? If I were forming a business entity, I'd probably do that as an LLC. That's what I would do. I think that would make the most sense. And again, it really depends on the level of risk. You may not need to form a business entity at all, depending on what you're selling, right? But if you're selling something that is inherently dangerous, some type of chemical or whatever that could burn or make somebody sick or whatever, then, I think it would be a good idea to form an LLC to give you some liability protection. And I would also, I would be remiss if I did not say that there are other ways to mitigate your risk as a business owner. You can do that by having good consumer or customer contracts that limit your liability. They can agree to limit their rights to sue you in the event of a claim. So you can use contracts to mitigate your personal risk for business claims. So don't overlook that as something that's important. One of those things that you might want to do after your business is born, right? Those other agreements that I think are important for you to be thinking about. That's something that you want to think about. You don't get to have that conversation with your attorney whenever you are using a DIY business formation process. So you may never have any idea that might be something that would be a good idea for you to protect your personal assets. But with Legal Shield's business product, you do. Why would a large corporation change to an LLC? Well, there might be a lot of reasons why they would do that. They probably wouldn't change to an LLC because that may be deemed to be a dissolution of the business. Whenever you change business entity, switch from one to another, that's a kind of a complicated thing to really think about, but it can trigger capital gains on all of the business owners, and oftentimes they don't want to do that. So I think you'll find that it's pretty rare that a corporation, especially a large one, is going to change to an LLC. That's usually a very complicated tax question. It may also violate various contracts that the business has because the corporation goes away. It may violate covenants in agreements or loan agreements, things of that nature that the business has. So for a lot of different reasons, that's probably not something that you're going to see around. You might see a small corporation convert to an LLC for some reason, but sometimes they can get the tax benefits they're looking for, in other ways. Let's see, Jimmy, did I answer your question about forming in other states? You can unmute yourself and just belt it out.
Yes, you did.
Okay.
I submitted that question before you addressed it.
Okay. So let's see, Steve is asking, if you are a solopreneur, I've never heard that term before. That's a new one to me, so I learned something. And you are an independent contractor, I guess you're doing work for someone else, and they've classified you as an independent contractor. Will the amount of revenues be the deciding factor for incorporation or the amount of increased risk? Well, I really do think that I think mitigating risk is a very important consideration in deciding to form a business entity or not. It's probably the most important, especially early on. The amount of revenues, I think that's relevant, right? Again, you have to make enough money, I think, to justify the expense of forming a business entity and the carrying costs associated with it. So that's, very important as well. You may want to think a little bit about whether you've been properly classified as an independent contractor with whomever it is that you are doing work for and they're paying you money. You may or may not be appropriately classified as an independent contractor, and you might be able to lay off some of your tax liability on whoever it is that's paying you, because if you were classified correctly, they might be sharing the load on your self-employment tax. So there's kind of a variety of different ways to look at that. Yeah, when I put it on YouTube, we do put it under the same name as the title typically. Yeah. Oh, no, I already answered that. Okay. Any other questions that anybody has that I can answer for you? Just, unmute and belt it out if you want. No, Emmy, do you have any
Hi.
comments that you wanted to share?
Yeah, Michael Fiffik, Fiffik. This
Yeah.
is Julie Reeder.
Hi, Julie.
Hi, I have a question. I just wanted to know about the LLC. Do you have to pay renewal fees every year for your paperwork that you filed with the state?
Yeah, that's a good question. I'm glad you asked, Julie. That's going to be, the answer to that question is going to depend on what state you file in. So what I can tell you, because I practice in Pennsylvania, is that there is a decennial filing, meaning every 10 years, you have to pay a fee to the state. It's just a pure revenue generator for the state. And they, the consequence of not doing that is that your name now becomes available. If somebody else were to ask for it, they ostensibly could give your name away. That's really the primary consequence, at least from my perspective, of failing to do that. I mean, there are a lot of businesses that forget to do that, right? It's every 10 years. But whether you have to pay it, the timing of it, and the consequences of not doing it are going to be different, I think, in every state. So that's a good question to ask your attorney along the way. But thank you for asking that. That was a good one.
Oh, so it's every 10 years then?
In Pennsylvania, it is, yes.
Oh, okay, excellent. Well, that's good then. At least you have 10 years to generate some revenue to pay it.
Yeah, it's not very expensive, like $125, I think it is, last time I checked.
Thanks.
Any other questions?
Michael, can I ask a quick question?
Yes.
I just recently started an online business selling all the headphones and electronics, and we're not making any money yet. So should we set up an LLC where we start the online store, or should we start the LLC after we start making profit and revenue? Thank you, sir.
Yeah, I think, well, hopefully your phones aren't blowing up and burning people. I know that they can do that kind of thing, but I would probably wait until you had a little bit of revenue before I would get too concerned about filing an LLC. So, make sure that you've got customer agreements as well that limit your liability, maybe limit your liability to only a return or a refund or replacement of the product. So you can set your own terms and conditions when you're selling, or maybe the online platform that you're selling has some type of a similar agreement that protects you too. So at least in the interim, that might be what I would be focused on.
Yeah, I will consult with you maybe later on. Thank you, sir. Thank you, Michael.
Yeah, feel free to call us. Okay, well, it's about 6:30, so we've gone pretty long. I'm sorry. I knew that material was very dense. I apologize. It was so much in there. I tried to get through it as best I could. So thank you for your patience and bearing with me to get through that. I really appreciate everybody attending the webinar. We'll do this again. We'll have some more webinars where maybe we can take a little bit of a deeper dive into some of these subtopics that we covered today. So please, if you haven't already, subscribe to us at Eventbrite. That's where we post all of our webinars and events, and you'll get a ping in your email whenever we do post a new one there. We very much appreciate you supporting our webinars, and we hope to see you soon. Have a great evening, everybody. Take care.
Thank you. Hey,
Bye-bye.
Michael,
Yeah.
Thank you, Michael.
quick question. Does the next event you're doing for special needs, is that open for anybody?
Yes. Yeah,
Okay.
please invite. Our webinars are open for anybody. So please invite your friends, your customers, your prospective customers. Feel free to invite them.
Thank you.
Thank you. Bye-bye.
Bye-bye.